evidence real property crossover question from February of 1988 is not my idea of a very good essay question. I don't think this is a well-constructed fact pattern because it tests an area of law that's much better tested on the multi-state than here. There's really nothing about this fact pattern that I think is very good. And that's why I share it with you. I think it's important to be aware of the fact that the bar examiners can give really off-handed questions like this one, which are rather difficult to organize and which are, at least to some extent, testing rather unconventional material. That's why having a very clear idea in your head about how to approach all of the different subjects comes in handy, particularly on tricky crossover questions like this one. Have a look at the call of the question. No numbers this time around. First, we are asked, was the trial court correct in excluding Allen's testimony of his 1975 conversation with Owen? Discuss. It's a clear evidence question, so we will address it the same way we address all evidence issues. We will start out with relevance, then we'll consider various objections. Finally, we will reach a conclusion and we'll decide whether or not the court was correct in excluding this testimony. Next, we are asked, was the trial court's judgment in favor of Owen's estate correct? Discuss. Well, this sort of puts us on notice that this might be a wills and trusts problem, and as it turns out, it really isn't, even though one of the parties in the litigation is an estate. Well, let's have a look at the fact pattern. Here again, a clear understanding of how the material is tested can help us with organization. In paragraph 1, we meet Owen, who dies in the very first sentence in 1986. Remember, this is a 1988 fact pattern. Right after the death, the executor files a complaint against Allen to recover possession and to quiet title in Blackacre on behalf of Owen's estate. Blackacre is 100 wooden acres of foothill land 50 miles from a city. Allen raised all appropriate defenses and counterclaims, and the last sentence we get here is an adverse possession statute. An action for recovery must be commenced within 10 years after the cause of action shall have accrued. That means that we are now on notice that it's likely part of our answer is going to be organized around the elements of adverse possession. And if you remember from our real property seminar, I do adverse possession in a very stripped down way, and a way that actually has appeared on California Bar Examination example answers published by the bar. So this isn't something that I just dreamed up. It's been a common approach in bar review circles for years. So the bar exam approach to adverse possession is we talk about a mental element, a physical element, and a time element. Now, if you happen to be a scholar on adverse possession and you've got one of those 5 or 6 part checklists memorized, go ahead and use it. I'm not suggesting that you dumb down your understanding of the law in order to take this exam. Heaven forbid. But if you need a stripped down, efficient approach, as I did, this approach works. And in any event, the last sentence in paragraph 1 tells us that one of Allen's claims to this property will be based on adverse possession. So, with regard to answering the second question that we're asked, whether or not the court ruled correctly in favor of the estate, we have to evaluate Allen's claim or claims to the property. And at the end of paragraph 1, we know that one of those theories is going to be adverse possession. So now take a quick step back and recall the 2 questions that were asked. We can already organize the evidence part of the question by using the relevance, objections, and admissibility elements. With regard to the claim between the estate and Allen, adverse possession will be at least one of those elements, and we can break it down into pieces too. Now look at paragraph 2. Here we see that the chain of title involves Owen taking title in 1955, and it's been in his name ever since. What Allen wanted to testify to, and what we are asked about in the first question, is while he and Owen were camping on Blackacre in 1975, Owen said, "I'm giving you this 100 acres as a college graduation present. From now on, it's yours." Close quote. The court sustained an objection to this testimony, stating it's hearsay and the witness is incompetent to testify anyhow. Great. Well, now we've got the 2 objections, competence and hearsay. And the hardest issue in this fact pattern is the issue of competence. And if you're not sharp on the real fine points of evidence law, you won't really have a clue about why Allen might be incompetent. If you don't know this little bit of law, you're pretty much on your own here. If you've done a lot of multi-state questions, probably you know something about the dead man statute, which used to prohibit people testifying about something that a dead person said, since we can't question the dead guy about what the alleged statement was. Well, the federal rules of evidence have abolished the dead man statute, and, therefore, there is plenty of room for us to conclude either way. Handling this difficult issue didn't really require knowing the correct answer. It just required thinking on your feet and making sense out of the facts. That, too, is sometimes easier said than done. So now turn to paragraph 3. Here, Allen is able to establish a lot of facts that relate to adverse possession. He spent a lot of time on Blackacre after this camping trip. He cleared some of it, he built a cabin and a barn on it, he put fencing up, and he paid taxes. It's very uncommon for an adverse possession question on a California bar exam for the claimant actually to have paid the taxes. So this looks like quite a strong adverse possession claim. But read on. In 1979, he left Blackacre to attend graduate school. But during that time, he had a tenant lease Blackacre from him to raise sheep. And the shepherd did so. When the shepherd's lease was up, Allen resumed possession. So it looks as if an adverse possession claim is established. But read on. In 1981, Owen hired surveyors to lay out a recreational subdivision on Blackacre. And that looks like an exercise of dominion and control. They were there for 3 weeks, they took measurements and put markers down, but they didn't do anything else. So judgment was held in favor of the estate. And now we get the questions again. Now I can tell you once again that this was not a question that the State Bar really thought there was a correct answer to. This is kind of an interesting real property question, and a very good case can be made either way. The fact that Owen had these surveyors come out does suggest that he believed he owned it. And if that's the case, if Owen still owned Blackacre in 1981, well, that would be justification for finding for the estate. But it seems to me that the adverse possession claim is so solid, particularly given the fact that Allen has paid taxes, that I would find that the trial court erred. Okay, so that's the intellectual content of the fact pattern. Take a look at the outline of issues that I've presented, and I think you'll see that this is certainly a sensible way to organize an answer. With regard to the testimony of Allen, even in the heading, I indicate that I think the court was wrong. Then, I just do a standard evidence analysis. I start with logical relevance. Clearly, this testimony supports the plaintiff's claims to this property. The first objection that was presented is hearsay, but we can argue first that it is a non-hearsay statement based on the effect on the listener or an act of independent legal significance, either one of which I think is justification for letting this statement in. And there is a hearsay exception, a declaration against interest by Owen. It's pretty simple. But the second objection is, as I've already indicated, the single hardest problem in this fact pattern, the competence of Allen. Well, you've got to know the dead man statute to do anything other than jive your way through. But the correct answer is Allen almost certainly is competent. So now we move on to consider the trial court's judgment in favor of Owen's estate. Here again, I think the court got it wrong. I think that Allen has a valid adverse possession claim. The three elements that I present are self-explanatory, and I also think that Allen has a contract claim based on a donative gift plus detrimental reliance. But I admit that's sort of a tertiary theory, although I do have to say it is another winning theory for the plaintiff. So once again, we've seen how to apply our knowledge of the different subjects that we've got to impose order on an otherwise rather complicated crossover question. That's the basic skill that we are trying to reinforce here. When we've got two different subjects being tested, especially in a somewhat offhand way like this fact pattern, we've got to resort to our background approaches and impose order on the answer based on our knowledge of the law. Now let's turn to the answer and briefly have a look at the evidence section. you'll see that under relevance, I lead with the facts. I explain what the testimony is and why it's relevant. I discuss hearsay, and I explain both that the court sustained this hearsay objection, and I briefly define hearsay. Then we go into the analysis about it being hearsay. Here, these paragraphs are very short and to the point, and it's possible that you might be able to do a more elaborate job than I did. But still, I think that I've written an answer that clearly covers the ground here, and that is sufficiently lawyerly to impress the disinterested grader. Next, we focus on the hearsay exception, the declaration against interest. Here, again, I think I've made a clear legal point in the context of the facts. So, here, writing the answer isn't really very difficult. Spotting these complicated issues and organizing the details carefully, well, that's where the hard work comes in here, and it's work that you should do before you write one word in the Blue Book. Next, we turn to the competence objection, and here I dash it off in just a couple of short paragraphs. I know about the dead man statute, so I can make pretty quick work of this objection and then move on. Next, we turn to the real property element of the question, and we focus on adverse possession. That's really the core claim. All of the facts that we've got really point to adverse possession. So you'll notice that I talk about all of the relevant facts with regard to the physical occupation of Blackacre. I tie in the explicit language of Owen at the time of the purported grant. I use it to establish hostility. You could use this quote also in the section about a purported contract theory. And, in fact, I chose to emphasize the adverse possession section over the contract section because I think the facts speak to adverse possession a little bit more clearly. With regard to the time element, here the facts are most complicated, but still I'm able to interpret them, I think, fairly clearly and concisely. The contracts claim is another element of the answer which many unsuccessful candidates who got, say, a 65 failed to spot. And I think it's worth at least 5 points on a marginal question like this. Here we talk about an oral promise plus detrimental reliance. That's really enough to establish the contract claim, and here I focus on the defense in contracts, the statute of frauds, and I indicate part performance would be good enough to take it out of the statute. And so, finally, I conclude that Allen has good claims to this real estate, both by adverse possession and by contract. And so, ultimately, I think the court got everything wrong. I think the court's refusal to admit the evidence was in error, and I think that the court's determination in favor of the estate also was in error. Once again, here I go finding for the defense.